Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Illinois. Yes, we get to talk. We get to talk about an assault weapon ban. Gosh, we've never done that before, have we? Yeah, actually, I probably have covered no out-of-state topic outside the state of Washington anymore than Illinois' absolutely grotesque and horrifically unconstitutional assault weapon ban. As you know, Illinois, you just had a big trial last week down there in the southern part of your state. We're going to do a little highlight reel from that. We're also going to talk about a lot of other very important announcements that we have as it relates to Washington gun law heading out your way to the land of Lincoln. So today, let's spend a few minutes, let's geek out for a bit, and let's talk about, is Illinois' assault weapon ban about to be overturned again? Okay, hey, before we get going too far down the road, Illinois proud to announce that Washington gun law, thanks to the good folks at Right to Bear, yeah, we're coming your way. October 14th, 15th, and 16th. We are going to be in Illinois with our good friends from Right to Bear, and we want you to join us. So, right now, we are going to be Monday, October 14th, and Tuesday, October 15th, we are going to be at Gat Guns in East Dundee. And then on Wednesday, October 16th, we're going to be at Law Weapons in Naperville. I want to see all of you. Come on by for one or all of those days. Hang out with us. Meet the good folks at Right to Bear. See what they can do to make your life a lot better in the state of Illinois. I know you need a little help like that. So, just remember, October 14th and 15th, we're going to be at Gat Guns in East Dundee. October 16th, we're going to be at Law Weapons in Naperville, Illinois. I can't wait to see all of you. Thanks again to our good folks at Right to Bear for setting this all up. We'll see you next month. Okay, Illinois, here's what we're talking about. We're talking about the case of Barnett v. Raoul. We're talking about the case of Harold v. Raoul. We're talking about the case of Langley versus Raoul. We're talking about the case of Jake and Elwood Blues versus Raoul. We're talking about all the consolidated challenges to the Protect Illinois Communities Act, better known as your unconstitutional assault weapon and magazine ban, which just went to trial down in the Southern District of Illinois, the United States District Court down there for the Southern District of Illinois. Now, before we get too far into the highlights, you guys may have gotten live play-by-play from Bishop on Air. And listen, if you're not following Greg Bishop, who reports for the Center Square and Bishop on Air, Illinois, you are very, very fortunate to have him looking out for all of your interests and rights down there. We're going to link them up down below. If you're not checking them out, Illinois, you better get on it right away. Okay, the trial began on September 16th. It concluded on September 20th, and we're going to kind of go through, give you a few of the highlights, the lowlights, and try to figure out what might happen here. Now, for those of you who routinely geek out on this channel, thank you very much. You will recall that we did this video a couple weeks ago, and it had talked about how there had been other challenges outside the Second Amendment that had been brought by the litany of plaintiffs that were coming to this lawsuit, including a Fifth Amendment challenge on self-incrimination, which we thought actually had some legs, but the trial court did not, granted summary judgment, chucked it out on behalf of the state of Illinois. There was also another claim that was brought under Fourth Amendment, unreasonable searches and seizures. That too was summary judgmented out of the case. So all of these plaintiffs went forward on purely a Second Amendment, 14th Amendment analysis. Now, I know a lot of you were freaked out like, oh my God, this judge is already throwing challenges out, but let us not forget that this is Judge McGlynn, who previously has ruled that this law is in fact unconstitutional. If you will recall, in fact, we ended up doing this video right here with the good folks out there at Gat Guns. You will recall that we actually had an injunction where you could purchase those weapons, even though PICA had already been enacted, as if you were living in the United States of America. Unfortunately, Judge McGlynn's order was short-lived. The Seventh Circuit swooped in, took it over immediately, stayed the injunction, and then ultimately a full en banc panel of the Seventh Circuit in upholding that stay ruled that, shockingly, America's most popular rifle is not even protected by the Second Amendment. Now, the state of Illinois defended this ban in exactly the same fashion, one would think, including trotting out all of the horror stories. Because when you don't have facts, when you don't have empirical data, when you don't have the law and you don't have the Constitution on your side, really about the only thing you can do is trot out the horror stories. And so that's exactly what they did. Now, some of their other arguments, of course, included, well, the AR-15 is essentially tantamount to an M16. They look pretty much the same, and for that reason, since we can regulate the M16, we can also regulate the AR-15. Of course, they were pounding and pounding over and over on the drum from the Seventh Circuit that had ruled, actually, that because these weapons were more appropriate for military use, the Second Amendment did not even protect them whatsoever. Now, I know that that may seem like that's persuasive authority, but that was a ruling that was on the injunctive relief, and therefore Judge McGlynn is not bound by it. And let us also remember that after the Seventh Circuit issued this now infamous ruling, Judge McGlynn was quoted as saying, "Just because an arm has a cousin in the military does not mean that that arm is beyond Second Amendment protection." Now, of course, the state of Illinois also trotted out many of the other usual arguments, which is, oh, a pistol grip makes it easier to shoot, therefore makes it more deadly. High-capacity magazines makes it more easier to shoot, therefore more deadly. Same with the barrel shroud, and on and on and on. The plaintiffs did a very nice job of pointing out that, well, what you're talking about is you're talking about making a shooter more accurate and proficient in the use of the firearm, which would mean that would also equate to better equipping it for self-defense. But ultimately, the most offensive argument in a long, long list of offensive arguments was the state of Illinois arguing that, hey, what do you need this for? I mean, you don't need one of these firearms. And I didn't get the memo that said that we had to justify our rights based upon needs. Does anyone ever ask you, why do you need to go to church on Sunday? Does anyone ever ask you, why do you need to be able to speak freely? Why do you need to be able to be free from unreasonable government searches and seizures? Why do you need to be free from having to incriminate yourself? Why do you need to be free from cruel and unusual punishment? No, because we don't base rights on needs. But even more offensive then is that after the state of Illinois says, well, what do you really need that for? What the state of Illinois also argues is, well, we should be the ones, exclusively the ones, that determine what your need really is. And so whatever you believe, whatever you feel, whatever you think is absolutely irrelevant to the equation of how you want to protect your life. Did the court tip its hand such that we might know where the court's going to lean? Well, according to those that were in the courtroom, Judge McGlynn spent considerable time after closing arguments talking about some very dark chapters in American history in which violence was inflicted upon racial minority groups, and commented on how those attacks may have never occurred, or certainly the results may have been quite different from a historical standpoint had those groups been allowed to be armed. And in fact, Judge McGlynn, and correctly so, pointed out that confronting evil is essentially ingrained into the moral fabric of who we are as a nation. So for all of those reasons, what is our prediction? Well, our prediction, the same as it was on this video, can be summed up in 4 words. Win, stay, appeal, lose. What do we mean by that? Win. Well, yeah, we believe that Judge McGlynn is going to find this law unconstitutional once again. That will be the win. However, the state of Illinois will immediately appeal, and the Seventh Circuit will swoop in and stay any injunction. There's your stay. There will be then a formal appeal by the state of Illinois, which may be argued first to a 3-judge panel and then ultimately to a full en banc panel of the Seventh Circuit. That will be your appeal. And having already seen what the Seventh Circuit thinks about this platform of firearm and the applicability of the Second Amendment to it, that is why we predict that ultimately this will be a loss. Now, this may all stall out because, as we know, there is a case out of Maryland, Bianchi versus Brown, that is sitting before the United States Supreme Court on a petition for certiorari. And clearly, if the United States Supreme Court decides to accept review of that, this case will likely be stayed pending the outcome. Okay, the cases once again are Barnett v. Raoul, Harold v. Raoul, and a whole list of others. We're going to go ahead and link up everything that we talked about in making this video so you guys can geek out on it for yourself. Maybe you got more questions about this or anything else related to what's left of our Second Amendment rights. Now, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. Maybe you got an idea for a video we should be doing around here. If you do, go ahead and click on that link right there and let us know. It's probably better than any idea we're going to come up with. Maybe you just want to subscribe to our monthly newsletter. The ability to do all of that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.